the top, the latest on the school shooting in Georgia this week. The father of a 14-year-old, Colt Gray, accused of killing 2 students and 2 teachers at Appalachia High School in Winder, Georgia, has been charged with involuntary manslaughter and second-degree murder. Gray was known to law enforcement before Wednesday's heartbreaking tragedy. The FBI investigated and interviewed him last year related to online threats.
4 counts of involuntary manslaughter, 2 counts of second-degree murder, and 8 counts of cruelty to children. Mr. Gray, these charges stem from Mr. Gray knowingly allowing his son, Colt, to possess a weapon.
Colt's father, Colin, was arrested on Thursday, and this comes just 5 months after a couple in Michigan became the first parents convicted and sentenced for a U.S. school shooting ever before. The charges now pending against the 54-year-old Colin Gray in Georgia could signal a sea change here in how prosecutors handle school shootings. Meantime, although former President Donald Trump's January 6th criminal trial may be delayed, we could get a look at never-before-seen evidence sooner than later. For the first time in nearly a year, Trump's defense team was in the D.C. federal courthouse this week for a hearing in the January 6th case. After Special Counsel Jack Smith filed a superseding indictment against the former president last week, Trump is still facing the same 4 charges for his efforts to overturn the 2020 election. Those charges include conspiracy to defraud the United States and obstruction of an official proceeding. On Thursday, Trump lawyer John Lauro pleaded not guilty on Trump's behalf to the renewed charges. Judge Tanya Chutkan also set a timeline for both sides to make arguments about how the Supreme Court's recent ruling on presidential immunity applies to the case now. Those filings could include damning evidence that has not yet entered the public domain. Chutkan also admitted that it would be, quote, an exercise in futility at this point to set a trial date, because the immunity issue, particularly whether Trump's pressure campaign on the vice president is immune, will likely get appealed at least one more time. If those conversations with the vice president are immune, it could deal a major blow to the special counsel's case.
I think they have a hard case if it ends up getting stricken. I mean, what he did was he cast the vice president in his role as the presider over the legislature. And by doing that, made it look like these were less about executive official acts and therefore more along the lines of unofficial acts of a campaign. And so we'll see if that will work. The Supreme Court was not clear on this issue.
A reminder here, the Supreme Court essentially created 3 tiers or levels of presidential conduct in their immunity decision. Chief Justice John Roberts, writing for the majority, said a president enjoys absolute immunity for acts within his core constitutional powers. That includes acting as commander-in-chief, presidential pardons, and communications with his cabinet officials, including the attorney general. In this category, the court held that Trump is absolutely immune from any criminal charges related to pressuring former acting Attorney General Jeff Rosen to help overturn the election results in Georgia, including threatening to fire Rosen and install Trump loyalist Jeffrey Clark. Now, the second tier down, all other official acts that aren't necessarily a core power, but still within the president's authority. He enjoys either absolute immunity or at least the presumption that his actions are immune. The court said the president's pressure campaign on former Vice President Mike Pence falls into this category, including that Trump pressured Pence to use his role as president of the Senate to stall the vote to certify the Electoral College count on January 6th. And the third and final tier, unofficial acts are not immune. There was some debate between Trump's lawyers, who think the conversations with Pence are immune, and Judge Chutkan, who suggested the court's decision was not necessarily crystal clear on that point. We'll get a look at Smith's filing that may include some of that additional evidence later this month, September 26th. Meantime, Trump lost his bid in New York to get the hush money case moved from state court up to federal court for the second time. By the way, it took only a few hours for District Court Judge Alvin Hellerstein to reject Trump's efforts to bypass New York state courts in an attempt to get his 34 convictions thrown out. It's a tall order to convince a federal court that it has jurisdiction to leapfrog over a state court. And remember, Trump was charged under state law for falsifying business records in order to cover up a sex scandal with porn star Stormy Daniels. Hellerstein said Trump's defense team didn't meet that heavy burden. Now, Trump's lawyers have filed a notice of appeal to the Second Circuit. That's the federal appeals court overseeing cases out of New York. And Trump is in court Friday appealing the verdict against him involving E. Jean Carroll. He's trying to convince an appeals court that he should get a new trial after a jury found he sexually abused and defamed her. The court didn't issue its decision right away, of course, and one is unlikely before the November presidential election. Meantime, Hunter Biden, son of President Joe Biden, agreed to plead guilty to federal tax charges on the eve of his trial in Los Angeles. Biden was charged with 3 felonies, 6 misdemeanors for tax evasion and related crimes, including failing to pay at least $1.4 million in taxes. Before the deal came together, the day jury selection was set to begin, Hunter originally offered to enter into an Alford plea. An Alford plea, named after a 1970 Supreme Court case, requires a criminal defendant to enter a guilty plea but allows that same defendant to maintain his innocence. The defendant chooses to plead guilty, recognizing that the prosecutor has the evidence to get a jury to deliver a guilty verdict, but maintains that he's innocent of the crime. Ultimately, it's up to the prosecutor whether to allow an Alford plea, and although Biden tried it, Special Counsel David Weiss's office was not buying what Biden was selling. An attorney for Special Counsel told the judge, quote, "I want to make crystal clear the U.S. opposes an Alford plea. Hunter Biden is not innocent. He is guilty." Instead, Biden pleaded guilty to all 9 federal tax charges, and the deal allows both Hunter and his family to avoid potentially embarrassing witness testimony recounting Hunter's years of drug and alcohol addiction. Hunter told the court, quote, "I will not subject my family to more pain, more invasions of privacy, and needless embarrassment." Biden will be sentenced December 16th, but had to acknowledge to the judge as part of this guilty plea that he faces up to 17 years in prison and over $1 million in fines. Meantime, Biden is set to be sentenced in Delaware this November after a jury convicted him on gun charges in June. And newly released body cam footage obtained by the New York Post reveals Atlanta's top prosecutor, Fani Willis, showing up to her daughter's arrest with Nathan Wade. And the kicker, it's months after both she and Wade said their romantic relationship was over. Recall Willis had tapped Wade to lead the prosecution of former President Donald Trump over his efforts to subvert the 2020 election results in Georgia. Wade later resigned amid public revelations about their personal romantic relationship. Willis's daughter was pulled over on August 24th for driving with a cell phone and then arrested for driving on a suspended license, according to the Post. Willis and Wade were evidently able to arrive on the scene quickly, together, and in casual clothes. Wade testified that their romantic relationship ended June 2023, but they remain friends.